Hi, so welcome back to the English Law channel, and carrying on with tort, I'm going to look about the idea of there being no liability for an omission to act. So non-feasance, generally speaking, does not carry liability. So sometimes people say you're morally obliged to help people when you can rescue them, but there's usually no legal obligation to come to their aid. So Stoven and Wise was a 1996 case about this. So there was a road verge which blocked motorists' view of the road as they're coming around a curve. And that was a cause of a few accidents. Norfolk County Council controlled the road. They had been notified of the problem, and they had the legal power under the Highways Act 1980 to order the earth bank to be dug out. The land was privately owned on the ground that that bank was blocking the view. So they decided they were going to remove the hazard, but the then authority didn't actually tell the landowner to do so. They hadn't got around to do that. So Mrs. Wise negligently was unwise and drove out from a side road, and caused an accident. Now she said that the dangerous junction with a blocked view had materially contributed to the accident, so the fault was not all hers. So remember, it's held that the no liability for omission was applicable here. So the breach was a pure omission, and the defendant had not created the harm, suffered. The House of Lords, by a bare majority, though, found that the local council did not have a duty of care to road users for the local council's failure to use its powers to have the bank removed. So Lord Hoffman, who was speaking for the majority, said that there are various reasons for this decision, and this is what he said. There are sound reasons why omissions require different treatment from positive conduct. It is one thing for the law to say that a person who undertakes some activity shall take reasonable care not to cause damage to others. It is another thing for the law to require that person who is doing nothing in particular shall take steps to prevent another from suffering harm from the acts of third parties, like Mrs. Wise, or for natural causes. Anyway, that's enough from him. So Lord Nichols dissented, and he said that we ought to impose liability for some omissions. He concurred that often it's unclear about categorising omissions, but he said it's right that there is a presumption against the duty of care in these cases. However, he said this is why this was an exception, this Wise case. The recognised legal position is that the bystander does not owe the drowning child or the heedless pedestrian a duty to take steps to save him. Something more is required than being a bystander. There must be some additional reason why it's fair and reasonable that a person should be regarded as a brother's keeper and have legal obligations in that regard. When this additional reason exists, it is said there's sufficient proximity. That is the customary label, close quotation. So remember, the omissions principle came up in Robinson against Chief Constable of West Yorkshire Police, 2018, which went to the Supreme Court. And here's what Lord Reid, a Scottish judge, had to say about it. The distinction between careless acts causing personal injury, for which the law generally imposes liability, and careless omissions to prevent acts by other agencies causing personal injury, for which the common law generally imposes no liability, is not a mere alternative to policy-based reasoning, but is inherent in the nature of tort of negligence. For the same reasons, although the distinction, like any other distinction, can be difficult to draw in borderline cases, it is of fundamental importance. Close quotation. So English law does not have this law requiring you to be a good Samaritan. There are some exceptions from this. So you have a duty to act positively if there's a special relationship. For example, if you're a parent, that's your child. In deciding what the situation is when the general rule doesn't count, various criteria need to be found to exist. If the defendant has entered into a special relationship with the claimant, then the law says that you have a duty to stop that person coming to harm. So the occupier of a premises to his visitor, an employee to its workers in the workplace. The Ogopogo 1972 was a Canadian case about this, where the defendant invited the claimant to be a guest in his yacht. The claimant then fell off the yacht. So was there a relationship between the host and the guest, one that carried a legal obligation? The defendant wasn't simply a bystander and was found to have a duty to take reasonable care to try and save the person. What if the defendant has assumed responsibility for the welfare of the claimant in some respect? Then there'll be liability. Phelps and Hillingdon, London Borough Council, the House of Lords said that educational psychologist who was employed had a duty to Miss Phelps to diagnose her dyslexia, which she had, The decision was because the educational psychologist was there particularly to advise about education and to assess people for any learning difficulties they had. And it was blatant that the parents are going to be guided by that advice. And this is what Lord Slynn said about it. And that phrase can be misleading in that it can suggest that the professional person must knowingly and deliberately accept responsibility. The phrase means simply that the law recognises that there is a duty of care. It is not so much that the responsibility is assumed as it is recognised or imposed by the law. There's another sort of assumption of the duty of care in Barrett against Ministry of Defence 1995. There was a relationship of proximity between defendant's conduct and the claimant's harm. Therefore, there was an assumption of responsibility. There was a pattern of heavy drinking by soldiers at a military base, where, remember, in the military there's tax-free alcohol. One evening, after a debauch, a soldier fell unconscious. The duty officer had him taken to his room, where he was left and not superintended. He later died because he'd choked on his own vomitus. And his widow brought an action in negligence against the MOD. Now, the Royal Navy ran the base, and they were not liable for preventing him drinking. Of course, he's allowed to get drunk for anything that happened prior to his collapse. But they'd assumed responsibility for him and taken him to his room. You might say the trouble is that incentivized you just leaving him collapsed in the pub or something like that, or hanging around doing more dangerous stuff. So there was proximity because they had some control over what was a dangerous situation. In Sut Radar against NERC, the House of Lords unanimously said that the defendant couldn't be liable for what they did not do. There was no proximity between the claimants and the defendant. Remember, that's about the polluted water in Bangladesh. If the defendant's been put into a position of risk or danger that they do not address, well, if the defendant might be liable to try and reduce danger or to get rid of the danger that they know of, even if they didn't actually create the danger. There's Goldman and Hargreave, 1967. The defendant had a tree that was like 30 meters high. Lightning hit it. The tree went on fire. The defendant caused the land around the burning tree to be cleared, and then the tree was cut down. But he didn't put out the fire after he did so, saying it'll burn itself out. But it carried on burning just slightly. Then a warm wind came along and it spread it. It burnt the neighbour's land. The defendant was found to be negligent because he'd not taken enough steps to put out the fire that was a foreseeable risk. So in this case, the defendant didn't have to show the care of a reasonable person, but only had to do what he could do, bear in mind his physical capability and his money. Because if he had loads of money, he could have hired loads of people to help him. In Capital and Counties plc against Hampshire County Council, a fire officer went to a fire and he said the sprinkler system should be switched off, which was exactly the wrong thing to do. Even I know that, because then the fire got worse. Just in case fire officers don't know, water puts out fires. Anyway, so there was no liability for not dousing the fire, but what he did was, had done liability was for the positive act of actually switching off the sprinkler system, which aggravated the damage. That's enough for the moment. Bye.